Welcome to Truth Behind History. Today we are diving into the origins of judicial power in the United States, and how a few key decisions and philosophical choices turned the judiciary from a quiet referee into a central architect of national policy. Here's a question most Americans never ask: who gave the Supreme Court the final say over everything? You might think it's spelled out in the Constitution that 9 justices were always meant to have the power to strike down laws, shape national values, and settle the most divisive issues in the country. But actually, it's not. Let's start with the Constitution itself, Article 3. It's remarkably vague. It says there shall be a Supreme Court, and it gives Congress the power to create lower courts, but it barely explains what judges are supposed to do. It certainly doesn't say they can overrule Congress, veto presidential actions, or decide the meaning of the law for the entire nation. There is no explicit mention of judicial review, that is, the power of the court to invalidate laws it deems unconstitutional. That power? It was claimed, and the man who claimed it was Chief Justice John Marshall. In the now famous case of Marbury versus Madison in the year 1803, he pulled off what some scholars call the boldest legal maneuver in American history. In a case that began with a minor paperwork dispute over judicial appointments, Marshall took the opportunity to declare that the Supreme Court, and only the Supreme Court, has the power to interpret the Constitution. That single ruling, Marbury versus Madison, gave birth to judicial review. And with that, the court elevated itself from a passive arbiter to the ultimate constitutional authority. But was that what the founders intended? Let's look at Alexander Hamilton, who wrote Federalist No. 78. Hamilton described the judiciary as the least dangerous branch of government. He saw judges as interpreters, not rulers. They were supposed to rely on reason, not will. They would have neither force nor will, but merely judgment. To Hamilton, the judiciary was meant to be a check, not a source, of political power. So how did we get from Hamilton's modest vision to the towering role the court plays today? The answer lies in how power fills vacuums. Because the Constitution didn't say exactly what the judiciary should do, it left room for interpretation. And in the early years of the Republic, that meant fear. Real fear. Many Americans, especially anti-federalists, worried about what could happen if unelected judges began interpreting laws in ways that ignored the will of the people. They had just fought a revolution to break away from unaccountable rulers. Now they feared that a centralized judiciary might quietly recreate that dynamic, cloaked not in crowns or red coats, but in black robes and legal jargon. And that fear? It wasn't paranoid. It was prophetic. Because from that moment forward, the judiciary began to evolve, not just as a referee of legal disputes, but as a powerful force shaping what freedom, justice, and government mean in America. Let's fast forward to one of the darkest moments in Supreme Court history, the case of Dred Scott versus Sanford in the year 1857. If you've ever wondered how law, something we often think of as neutral, logical, or even sacred, can be used to enforce evil, this case is Exhibit A. Dred Scott was an enslaved man who had lived for years in free states and territories. He argued that because he had been taken into areas where slavery was illegal, he should be considered free. Seems logical, right? But the Supreme Court didn't just rule against him, it obliterated any legal foundation for black citizenship in the United States. The court's decision, written by Chief Justice Roger Taney, declared that African Americans, whether enslaved or free, could never be citizens of the United States. Let that sink in. According to the court, they had no rights which the white man was bound to respect. And it didn't stop there. The ruling also stated that Congress had no authority to prohibit slavery in the territories. Meaning, the federal government couldn't even stop the spread of slavery if it wanted to. This wasn't just a legal decision. It was a bombshell in an already explosive national conflict over slavery. In the 1850s, the country was already on edge, divided between free states and slave states, with new territories caught in the political tug-of-war. The Dred Scott ruling poured gasoline on that fire. It confirmed the worst fears of abolitionists and Northerners, that the federal government was complicit in slavery. It shattered any illusion of compromise and set the nation on an irreversible path toward civil war. But here's the most important part for our purposes: Dred Scott showed what happens when the judiciary stops interpreting law and starts enforcing ideology. The ruling wasn't just about Dred Scott. It was about preserving a system. It was about using centralized judicial power to protect entrenched interests, even if that meant denying basic human dignity. This case exposed the terrifying potential of unchecked authority. It proved that courts are not always shields of justice. Sometimes, they are weapons of oppression. When a handful of unelected judges can strip an entire class of people of their rights, not through war or legislation, but through legal opinion, it forces us to ask, who controls the law? And more importantly, who does the law serve? This was the judiciary not as protector, but as gatekeeper, not as impartial referee, but as political actor, and it would take the bloodshed of the Civil War to begin undoing the damage. Now let's turn to a very different kind of power struggle, one that didn't center on slavery or race, but on money, labor, and liberty. We're entering what historians call the Lochner era, a 40-year stretch from the late 1800s to the late 1930s, when the Supreme Court took a hard stance on economic regulation. The core issue? Whether the government had the right to interfere in contracts between private citizens, especially contracts between employers and workers. The landmark case was Lochner v. New York in the year 1905. Here's the story. The state of New York passed a law limiting bakery workers to 10-hour workdays and 60-hour work weeks. Seems reasonable, right? Long hours, hot ovens. This was basic labor protection, but the Supreme Court struck it down. The justices ruled that the law violated the freedom of contract, which they claimed was protected under the 14th Amendment's guarantee of due process. In other words, the court said workers had the right to agree to whatever terms they wanted, even if it meant grueling hours under dangerous conditions, and the government had no business stepping in. This idea, that liberty included the unrestricted ability to make contracts, became the court's guiding principle, and over the next several decades, it used that principle to strike down a wide range of progressive labor laws, minimum wage laws, maximum hour laws, child labor bans, all swept aside in the name of economic freedom. But here's the twist. The freedom to contract wasn't equally distributed. In reality, it gave power to employers and corporations, while leaving workers with very little bargaining leverage. The court framed it as protecting liberty, but many saw it as protecting capital. This judicial hostility to regulation came to a head during the Great Depression. President Franklin Roosevelt rolled out the New Deal, a sweeping set of reforms to stabilize the economy and support the working class. But the Supreme Court pushed back. Again and again, it struck down New Deal programs as unconstitutional, citing the same old logic about freedom of contract. This created a full-blown constitutional crisis. FDR was furious. He even proposed a plan to expand the court and appoint new justices, what critics called court packing, in order to shift the balance of power. Then came a turning point. In 1937, the case West Coast Hotel versus Parrish upheld a Washington state minimum wage law for women. This was huge. The court suddenly reversed course. The so-called freedom of contract took a backseat to the government's interest in regulating the economy. Many believe the justices changed course to protect the court's legitimacy amid mounting political pressure. This shift marked the end of the Lochner era, but the legacy lingers. This period raises deep questions about how we define liberty. Is freedom just the absence of interference, or does real liberty sometimes require constraints to protect people from exploitation? It also reveals how courts can tip the scales of economic life, shaping not just what the law says, but how millions of people live and work. So ask yourself, when unelected judges define economic rules for an entire society, whose freedom are they really protecting? Now let's talk about a case that redefined the moral purpose of the law, Brown versus Board of Education in the year 1954. This wasn't just a legal battle. It was a moral earthquake. For nearly 60 years after Plessy versus Ferguson, the doctrine of separate but equal was the law of the land. Segregation was legal, not just tolerated, but actively enforced by state governments, school boards, and local courts across the South. But the NAACP, led by a brilliant legal mind named Thurgood Marshall, wasn't willing to accept that. They launched a strategic, patient campaign to challenge segregation, one lawsuit at a time. Their central argument was simple: separate is inherently unequal. In the case of Brown, the NAACP brought forward evidence that segregation in schools violated the Equal Protection Clause of the 14th Amendment. Black children were being denied equal educational opportunities, and the state was doing it in the name of the law. The Supreme Court, in a rare unanimous decision, agreed. The court struck down racial segregation in public education, declaring that it had no place in American schools. Brown versus Board didn't just overturn Plessy. It declared, for the first time, that the Constitution could not be used to justify racial separation. This was more than a court case. It was a moral turning point. But let's be clear, it didn't instantly fix everything. Yes, Brown marked a shift in federal authority. For decades, education had been a state matter. Now, the federal government was stepping in to enforce civil rights over the objections of state governments. This was a dramatic assertion of centralized power, one that would spark decades of legal and political resistance. In the South, many schools simply refused to comply. Governors blocked school doors. State legislatures passed evasive laws. White citizens formed resistance groups. Federal judges were ignored, and in some cases, threatened. So while the legal victory was historic, it also revealed the limits of law. You can write a ruling, you can cite the Constitution, but when cultural norms and political power resist change, even the highest court in the land can find its authority tested. Brown versus Board became a symbol of what law can do when it aligns with justice, but also of what law cannot do on its own. It takes more than rulings to reshape a nation. It takes courage, community, and sometimes confrontation. The fight for civil rights wasn't won in a courtroom. It started there, but it had to be fought on buses, at lunch counters, in streets, and in hearts. Few Supreme Court cases have ignited more controversy, passion, and enduring political firestorms than Roe v. Wade, decided in 1973. This wasn't just a legal decision. It reshaped American politics, and it never stopped echoing. At the heart of Roe was a question of rights. Does the Constitution protect a woman's right to terminate a pregnancy? The court said yes, grounding that right in the concept of privacy under the 14th Amendment. Now, if that sounds a little abstract, you're not alone. The Constitution never mentions abortion. It doesn't talk about privacy in those terms. But the court had, in earlier cases, developed what's called substantive due process, the idea that some rights are so fundamental they're protected even if not explicitly listed. So the majority in Roe argued that a woman's right to choose fell under this broader umbrella of personal liberty, a decision that would profoundly shape constitutional law and cultural politics for the next half-century. But here's the catch: because Roe lacked a clear textual anchor in the Constitution, it opened the floodgates for criticism. Legal scholars on both the left and the right questioned its reasoning. Some supported the outcome but doubted the legal logic. Others saw it as an outright act of judicial overreach, the court creating policy from the bench instead of interpreting the law. And then came the political reaction. Religious conservatives, who had long stayed at the margins of national politics, found a rallying cry. Evangelicals, Catholics, and pro-life activists began mobilizing. On the other side, feminists and civil liberties groups rallied to defend the ruling. Roe didn't settle the issue, it supercharged it. Political candidates started running on their positions about Roe. Entire judicial nominations were shaped around whether a nominee might uphold or overturn it. The decision became a symbol, not just about abortion, but about the role of the judiciary itself. Should unelected justices be allowed to decide questions of morality, or should such decisions come through democratic debate and legislation? Roe also revealed a profound tension in American law: the limits of legal resolution. You see, when courts step in to settle moral and cultural disputes, especially ones that are deeply tied to personal beliefs, they might resolve the legal question, but they often amplify the emotional one. Rather than healing divisions, rulings like Roe can deepen them. The aftermath of Roe was decades of litigation, state-level pushback, and increasingly sharp polarization. It created a political litmus test that has shaped elections, campaigns, and confirmation hearings ever since. And it left us with a sobering question: when the court declares a new right, is that a victory for liberty, or an invitation for endless backlash? Let's talk about the case that changed the meaning of political speech, and may have quietly rewritten the rules of democracy. Citizens United versus Federal Election Commission, decided in 2010, took a wrecking ball to long-standing campaign finance laws. But more than that, it forced Americans to confront a fundamental question: is money speech? Here's what happened. A non-profit group called Citizens United wanted to air a film criticizing Hillary Clinton during the primary season, right before an election. Federal law, at the time, prohibited corporations and unions from using their general funds for electioneering communications close to an election. That law was meant to prevent big money from drowning out the public voice. But Citizens United challenged it, saying the law violated their First Amendment rights. And the court agreed. In a 5-4 decision, the justices ruled that restrictions on independent political spending by corporations and unions were unconstitutional. They said that spending money, even by a large corporation, is a form of protected speech. Now let's pause there, because this is where things get complicated. The ruling didn't mean corporations could donate directly to candidates. That was still banned. But it opened the door for unlimited independent expenditures. That's where super PACs come in, political action committees that can raise and spend unlimited amounts of money to support or oppose candidates, as long as they don't coordinate directly with them. Which, let's be honest, is often a technical distinction more than a practical one. The result? A tidal wave of political spending. Billionaires, special interest groups, and corporate-backed organizations suddenly had a much louder megaphone. The post-Citizens United era saw campaign costs skyrocket, dark money groups explode, and trust in democratic fairness take a serious hit. Supporters of the ruling argue that it upholds free speech, that just because someone is rich or incorporated doesn't mean they lose their rights. They claim the government shouldn't get to decide who can speak, or when, or how loudly. But critics point out the obvious imbalance. If money is speech, then some voices, the richest ones, get to speak louder, longer, and more often than anyone else. And if that's true, is it really a free marketplace of ideas, or just an auction? This case wasn't just about campaign ads. It was about power, and who gets to influence the rules of the game. It raises deep concerns about centralized influence masquerading as individual expression, and it invites us to think carefully about the boundaries between liberty and distortion. When the tools of free speech become weapons of elite control, are we still operating in a democracy, or something else entirely? Now we arrive at the present, the 2020s, where the Supreme Court isn't just interpreting laws, it's shaping the entire direction of American life. We are watching the court operate at a crossroads, not just legally, but culturally, technologically, even existentially. Today's court is facing some of the most complex and divisive questions of the modern era. How should free speech apply in a world dominated by algorithms and private tech platforms? Where does the right to bear arms end, or begin, in a society shaped by mass shootings and militarized policing? And what does religious liberty mean in a world where the line between personal belief and public service is constantly contested? These aren't questions the founders anticipated, but they're shaping the future of liberty, privacy, and governance right now. And as these new dilemmas unfold, the court itself is more polarized than ever. Recent decades have seen a dramatic shift in how justices are selected, confirmed, and perceived. The nomination process has become a political battlefield. Lifetime appointments now carry the weight of generations. One justice's vote can determine the trajectory of civil rights, corporate power, digital privacy, and reproductive freedom, not just for years, but for decades. And that polarization? It doesn't stay inside the marble walls. The public now views the court through an increasingly partisan lens. Approval ratings swing with decisions. Protests erupt outside the building. Politicians openly campaign on reshaping the court. What used to be seen as the quiet, sober branch of government is now a lightning rod, and in many ways, a symbol of national division. At the same time, the court has become more assertive. It's not just reacting to laws passed by Congress. It's stepping in to define the limits of agency power, undo decades of precedent, and redraw the boundaries of state and federal authority. In many ways, the judiciary has become the final word on nearly every major political debate, even when Congress is gridlocked and the executive is constrained. So here's the big question: should the fate of democracy, liberty, and culture rest in the hands of 9 unelected judges? What happens when judicial philosophy becomes indistinguishable from ideology? And as more Americans lose faith in the impartiality of the court, where do we go from here? Because the future of the court isn't just about legal doctrine, it's about trust. And if that trust erodes, even the most powerful branch in government may find its legitimacy on shaky ground. So after everything we've covered, from Marbury versus Madison to Dred Scott, from Roe to Citizens United, from the moral clarity of Brown versus Board to the chaos of today, one question remains. Who guards the guardians? When the Supreme Court interprets the Constitution, who makes sure they get it right? When justices serve for life, who holds them accountable? When decisions shape the economy, society, and even morality, who gets to say they've gone too far? The founders built the judiciary to be insulated from politics, and that has its strengths. It can protect minority rights, resist mob rule, and provide long-term stability. But insulation can also lead to isolation, to unresponsiveness, to power that answers to no one. This brings us to the most overlooked question in American government: what happens when the court itself becomes a source of imbalance? Because history shows us that law is not neutral. It reflects values. It enforces systems. It distributes power. And when that power becomes centralized, when it becomes insulated from feedback, challenge, or correction, it starts to drift. Slowly, subtly, sometimes disastrously. So maybe the final lesson is this: no system polices itself, not even the judiciary. Real accountability requires more than tradition. It requires vigilance. It requires education. It requires people like you, willing to question what you've been told, to re-examine the myths, and to understand the deeper forces at play beneath the robes and rituals. Because the question of who interprets the law, and why, is never just legal. It's philosophical, it's economic, it's human. And if we don't ask those deeper questions, we'll keep mistaking authority for truth, and procedure for justice. Thanks for watching Truth Behind History. If you found this video thought-provoking, do me a favor, like, comment, and subscribe. Your support helps us keep digging into the stories most people never hear. And if you want to go even deeper, check out my book History They Tried to Erase. The link is in the description. And as always, if you're curious, skeptical, and hungry for truth, we've got more videos coming your way. Until next time.